Hello and welcome. If you or someone you love is preparing for an immigration court hearing, especially an individual hearing, this video is for you. Here at RIF, we will walk you through what to expect, answer some of the most common questions, and share a few important tips to help you feel more prepared. Please note this is for general information purposes only and not intended as legal advice. In immigration court, there are generally two types of hearings, the master calendar hearing and the individual hearing. The master calendar hearing is shorter and more administrative. It's where the judge checks in on the status of your case. The individual hearing, sometimes called the final or merits hearing, is where you get the chance to fully present your case for relief, like asylum or cancellation of removal. This is where you and your witnesses will testify, submit evidence, and where a decision may be made on your case. Some hearings are now held remotely by video, depending on your court and judge, but many are still in person. Always check your hearing notice closely. You can and should check the latest court information for your case by searching for the EOIR Automated Case Information website or the automated hotline and inputting your alien number, also called the A number. Having a lawyer can make a major difference, although it is not required. Keep in mind, immigration law is complicated, and an experienced attorney can help you present your strongest case, prepare for you for testimony, and make legal arguments on your behalf. The immigration court does not provide an attorney to you, so you have to find one on your own. There are private paid attorneys. Sometimes you can find a low bono attorney that is low cost, and there are also pro bono or free attorneys, typically through nonprofit organizations. If you do not have a lawyer, you can still represent yourself, but that means you have to make sure you are well prepared for your case and you have everything that you need. It's a good idea to reach out to legal service providers or nonprofits in your area to see if they can assist you for free or at a low cost. You can find a list of legal service providers on our website at www.rifnyc.org. The court will provide an interpreter for your language during the hearing. However, you should let the court know in advance what language or dialect you need. You do not need to bring your own interpreter, and in fact, personal interpreters are not allowed to interpret during the hearing itself. If you need to make an amendment or change to your application or any materials you previously submitted to the court, you can do so at the hearing. You can and should let the judge know if there are any mistakes in your application or testimony. It's important to be honest and clear. If something has changed or if there's something you need to correct, raise it early in the hearing so the record is accurate. Up until recently, every court had a deadline to submit evidence and documents, usually at least 15 days before your hearing. Submitting everything on time is critical. However, now it's very important to submit a complete asylum application more than ever, well in advance of your hearing. Judges now have the power to pre-terminate your case. That means they can dismiss or deny your asylum application without even hearing your full testimony if they determine your application is incomplete or legally insufficient on its face. To avoid this, you should submit everything necessary to support your claim ahead of time. Your declaration, that is, your personal story in writing, country conditions reports, letters of support, police reports, medical records, and any other relevant evidence that helps prove your fear of return. Missing or vague submissions can lead to pretermission or dismissal of your case. If your case is dismissed, you could be placed into expedited removal by ICE, so it's essential to be as thorough and timely as possible when preparing your materials. If you previously submitted a bare bones application, you may want to consider submitting an updated application with more details about your claim or with additional materials that you were thinking of submitting later. Always consult an attorney if you have specific questions about your case. Please note all documents in a foreign language must be translated into English, and you need to include a certification of translation for each one. It doesn't have to be done by a company, but the translator must be fluent in both languages and must include a signed certification letter stating that the translation is accurate and complete. You cannot translate your own documents, even if you're fluent in both languages. If you entered the US between May 11, 2023 and May 11, 2025 and are seeking asylum, be aware of the Circumvention of Lawful Pathways rule, also called the CLP rule. This rule presumes ineligibility for asylum for individuals who enter without using lawful pathways. To overcome this presumption, you must demonstrate that you meet one of the exceptions, such as if you are an unaccompanied child or Mexican national, if you entered lawfully with parole or a visa at a port of entry, if you applied and were denied asylum in a third country, if you presented at a port of entry without a CBP-1 appointment, but you can prove that you could not access the app due to a language barrier, illiteracy, significant technical failure, or other ongoing and serious obstacle. If you do not qualify for one of the above exceptions, you can still overcome the presumption of asylum and ineligibility by showing exceptionally compelling circumstances, such as a medical emergency, imminent and extreme threats. For example, if you travel through other countries or were staying in Mexico before reaching the United States, and explaining why you didn't or couldn't stay there. If you are a severe trafficking victim, or other exceptionally compelling circumstances, such as family unity. That means if you have an accompanying spouse or child who do not independently qualify for asylum without your application. It is very important to provide credible evidence for any of these exceptions that you qualify for. If you are found to be ineligible for asylum based on the CLP rule, you may still remain eligible for other relief, like withholding of removal and relief under the Convention Against Torture. Once again, the CLP rule applies to you if you are seeking asylum and you enter the country between May 11, 2023 and May 11, 2025, and you did not use the CBP-1 app or another type of parole or visa to enter through a port of entry. To recap, preparing for an individual hearing can feel overwhelming, but understanding the process makes a big difference. Know your hearing date and time. Submit your evidence early. Be honest in your testimony. Get legal help if you can. And don't forget, the court will provide an interpreter, but it's your job to prepare for your case. Thank you for watching. If you found this video helpful, feel free to share it with others who may be going through this process. For additional questions, you can also join us every week at our legal consultation meeting or check out our other monthly events at www.rifnyc.org. And remember, you're not alone.